Immigration Attorney Moumita. I'm coming to you live to talk to you about immigration and to say a quick hello. Merry Christmas to everybody. I hope everybody had a nice holiday, and I thought I would just take a few minutes to answer some questions live and talk to you about immigration before I go home because it's late in the day, but we are still working hard in this office. So I am here to talk to you about immigration and to see what's on your mind. Welcome to my live. If you are a current client, welcome. Thank you for trusting us with your case. I had the fortune of running into a client over the weekend, and it was always so magnificent. I love to meet my clients and see my clients in person. And also, if you are a follower, thank you for watching. I also ran into a follower this weekend as well. So that was really, really great. Thank you for watching. Thank you for following. And I hope to be able to continue to serve all of you as much as I can. So let's talk about immigration. I know that there are a lot of questions, especially regarding the VAWA update that USCIS put out last week, and I promised you I'm going to get you a much more in-depth video. But what does it mean? Does it mean that VAWA cases can no longer be filed? No, VAWA cases should and can still be filed. I don't know if you saw my pictures earlier, but we got so much mail today. We have filed so many cases. So VAWA cases are not over. Does it mean that your case is now going to be harder to win? Well, the truth is since the beginning of this year, the Trump administration has been trying to make VAWA cases harder to win because they have been submitting more requests for interviews, more requests for evidence, and just overall challenging cases a little bit more. So what this new policy update does is it does clarify that they will look at evidence a little bit differently, and they will also apply a couple of rules a little bit differently. But in my honest opinion, it is not really changing much of the way that VAWA works right now, and I will discuss more of that in depth. So if you have been afraid to file for VAWA because you think that you're not going to win because you don't have any evidence, that is still not the case, because you can file for VAWA no matter how much evidence you have or how little evidence you have. The law has not changed. And I will discuss more with you in the next couple of days regarding what a little bit more comprehensively about what the actual changes are, so you can rest easy, okay? All right, let's go ahead and see what people's questions are. I have a question from SHD Smurf. Hello, I used to be a DACA recipient. I could no longer afford and could no longer renew. Now that I'm married to a U.S. citizen, I was wondering if I could get my green card. I never left the country. That's a great question. If you are a DACA recipient who is now married to a U.S. citizen, can you still get a green card even if you no longer have DACA? And the answer is that you do not need DACA in order to get your green card through a U.S. citizen spouse. However, what you do need in order to make your life easier is you need to have a legal entry into the U.S. Because the fact is that if you are married to a U.S. citizen and you want to fix your status in the U.S. without having to leave the United States, the number one thing that you need is to have a legal entry. You need to have a proof of entry with inspection. You need to have a stamp in your passport. You need to have an I-94 card. You need to have a border crossing card. You need to have one of these things to prove that you have a lawful entry to the United States, because without it, you would probably need to leave or you would need to do something different. So what happens if you do not have proof of a legal entry into the United States, but you are married to a United States citizen and you want to fix your status? Well, number one, we can definitely look to see if your spouse is in the military. Many of you are familiar with what is called military parole in place, and this is available to spouses or parents of U.S. citizens who are in the military, who are either inactive or who are, who are veterans. And through military parole in place, what that does is that it essentially kind of like erases that unlawful entry that you have to allow you to have what is called parole in place. And with that, you can then file your application for adjustment of status. Now, what happens if your spouse is not in the military? What happens if they're not in the military, so you're not able to do military parole in place? Well, next we can look to see if you're protected through something called Section 245I, adjustment of status. This is kind of like a needle in a haystack, and I want you to consider whether or not your parent or you or somebody in your family had applied for you or one of your parents before April 30th, 2001, because there's a special thing that happened where if you had an I-130 or even an employer who filed a labor certification or an I-140 for you before April 30, 2001, then you might also be able to do something that is similar to military parole in place and basically kind of have like a what is considered to be a forgiveness of your unlawful entry so that you can adjust your status. And we have done this for many people, but the key is to have documentation, and you also have to show that you've been living continuously inside the United States for a very long time. So it's difficult. Now, what happens if you are married to a U.S. citizen, but you don't have lawful entry and you do not qualify for either parole in place through military parole in place, or you do not qualify for Section 245I adjustment status? Well, of course, number one, you can always do a provisional waiver to leave the U.S. and go for an interview abroad, but many people don't want to do this. But if you do want to do a provisional waiver, you have to prove that your U.S. citizen husband or wife would suffer extreme hardship without you. And how does it work? Well, it's like a three-step process. And at first we have to file the I-130, then we have to do something called a hardship waiver. And once that is approved, that is when you leave the United States in order to do your processing at the consulate in your home country. But keep in mind, this is only possible for people who have just that one unlawful entry. If you have anything more serious like the permanent bar, multiple entries, a deportation order, or other criminal issues, then this may not be the best thing for you to do, because if you get denied overseas at the consulate, then that means that you may not have an easy way to come back to the United States, or it could be years before you can come back, which is why people understandably do not want to leave for processing. So if you don't want to leave for processing, what are your options? Well, number one, we can look at the VAWA case. And this is one of my favorite types of cases because of the fact that it can help forgive so many of these things. So if you are in a toxic marriage where your spouse is hurting you physically or emotionally, they control you, they manipulate you, they threaten to call the police on you, they threaten to get you deported, they tell you that you should go back to your country, they threaten to take your kids away from you, they pressure you to have sex, they pressure you to do other things, and they generally just make your life miserable, then even if you do not have a lawful entry, the VAWA application is a terrific way to see if you can get your status fixed inside the United States without having to depart the United States, without having to leave the US, okay? And this can help forgive, you can apply for a broad variety of waivers, including waivers for misrepresentation, waivers for certain criminal offenses, and also, of course, most importantly, if you have the permanent bar and you leaving the United States or coming back to the US is related to what you suffered in your marriage, then you can even get the permanent bar forgiven through this. And we have had so many green cards approved just this year alone. I mean, first of all, I can't believe it's already December. So like the year feels like it's passed by, but we have had a record number of VAWA cases approved and also green cards issued. We have had green cards issued for VAWA both with an interview and without an interview. I would say about 50% of our clients got interviews, 50% did not get interviews. So, and we've gotten green cards for our clients' kids as well, those who also applied with them. So this is really, really a big beneficial thing. And for those of you who were considering doing the waiver and leaving the US, well, when you do that, it's going to take about, it's going to take about as long. It's going to take about 3 to 5 years. But during that time, you don't get a work permit and you're still living undocumented. So the risk is still real. Whereas with VAWA, you can also apply for a work permit, and sometimes you can even get a tribal document. Now, what happens if you don't qualify for VAWA, or your spouse is not a U.S. citizen or a green card holder, or if you have certain other problems like a false claim to U.S. citizenship, and you don't have a lawful entry, but you are married to a U.S. citizen, you want to get your green card? Well, if VAWA is not an option for you, military parole in place is not an option for you, Section 245I adjustment of status is not an option for you, then what I like to look at is the T visa. And the T visa is something that I still consider to be a miracle visa because not a lot of attorneys know about it. In fact, the cap on the T visa has never been reached. That is how few attorneys actually use it and apply for it. But almost every immigrant that I've met qualifies for the T visa in one way or another. And even for a lot of our VAWA clients do technically qualify for the T visa, but we're doing the VAWA because they're eligible for that. But the T visa is something that may apply to you if you have ever been in a situation in your life here in the United States, no matter how long ago it was, where somebody that you worked for trafficked you, or somebody that you were in a relationship with trafficked you. So what does it mean to be trafficked? Trafficked means to be, I want you to consider this. If you have ever been in a situation where somebody that you work for, or that you are involved with, or that you have a relationship with, whether they're an uncle or an aunt, or a wife or a husband or fiance, they basically get you to do things. They basically extract the labor out of you through the use of fear, through the use of force, through the use of intimidation, through the use of threatening with immigration. They get you to do work or provide services, and you do it because you are afraid of what will happen to you if you do not comply. Then there's a very high chance that you've been trafficked. So let me give you a couple of examples. You show up for work at your factory job, and your boss is breathing down your neck saying, work faster or I'll call immigration. What are you gonna do? You're gonna work faster, and you're gonna be sweating bullets trying to get everything done perfectly so your boss does not call ICE on you, right? That is them getting work out of you through the use of fear, the use of intimidation. Or let's talk about this. You are in a family relationship with somebody, and your family member tells you, you now need to stay at home, cook, clean, and watch my kids because I brought you here and you owe me for letting you live in the United States and being here. Well, that is called debt bondage, because they're telling you that you have to pay off a debt to for whatever reason, and now they're getting you to work. So you're doing all this work because you believe you're in debt to them. That is also trafficking. These are just a couple of examples, but it happens to more people. It happens to a lot of people. So if you are undocumented, you're in the US, you do not have a legal entry, but you are married to a US citizen, and you want to get a green card, these are some of the ways that you might qualify without having to leave the United States, okay? My name is Moumita Rahman, 212-248-7907. Here, I have a comment here from, what if your uncle forced you to marry a stranger to stay in his house? From Shoot Ashid, that is so interesting. If your uncle forced you to get married to somebody in order for you to have a roof over your head, then I would ask, what else happened? Did you have to do things with that stranger? Did you have to, there's probably things that happen. Yes, that could very well qualify as trafficking. Give us a call, Shoot Ashid, 212-248-7907. Is it safe to travel with your 10-year green card? From Sir Olu Ayo, is it safe for you to travel if you have a 10-year green card? Well, now, generally speaking, people with 10-year green cards are usually okay, but you have to understand that if you got your green card through marriage at all, or if you have any criminal issues, or if you are just in general worried about anything, I'm recommending to people to not travel unless they have to. But if you have a 10-year green card, you have a little bit more protection than others, because as a 10-year green card holder, they cannot just deny you entry to the United States. However, what Customs and Border Protection can do is they could try to pressure you to sign abandonment of your residency at the airport. So that's where the danger is. If you are returning as a resident and you have no right of privacy at the border, they could go through your phone, they could look for evidence to see if you've done anything. Maybe they want to question your marriage, and they see that you're no longer with your spouse, and then they want to accuse you of committing marriage fraud. Then they could try to pressure you to sign a form that's called the I-407, abandonment of residency, to make you give up your green card. And if you are a green card holder, this is the biggest danger that you face at the airport. If you are a green card holder and you travel and you come back and you have certain criminal convictions in your past or currently, or you have there's evidence or something that indicates that you have done something, they could use that as a basis to put you into removal proceedings. So should you travel as a green card holder? The answer is, well, it depends. It depends, and it depends on what your risk level is, what your comfort level is. Generally speaking, you still have some rights. So here's what I would say though: if you are a green card holder and you want to travel, then go ahead and travel. But make sure you never sign that form to abandon your residency at the airport, okay? Because the worst that will happen is that they might detain you or they might put you into proceedings, but at least you'll be allowed back in and you'll have a chance to fight. Whereas if you sign that form of abandonment of residency, then you won't. Then you'll have problems getting in. Peso mucho. I see your question. I'm gonna answer your question right now. Okay. Don't go away. So that's what I would say if you're a green card holder. Okay. Peso mucho. I'm scared I didn't have enough proof to file VAWA, and you're my lawyer. Peso mucho. I don't know if you wrote something before that. Okay. If you are scared, if you have been scared because you already submitted your VAWA case and you felt already bad before because you did not have enough residency, and I'm your lawyer, first of all, if I'm your lawyer, you should rest easy, because not only do we put together really strong cases as much as we can, but whenever we get a request for evidence, we fight back. I don't care what policy updates they have. I don't care what they're saying. The standard, the standard of law is still the standard of law. So any credible evidence is still the standard, guys. It's still the standard. And they even say that even an affidavit may be enough for a credible evidence, even in their new policy update. Okay. So what they are saying in their new update is that they now have the power to determine what is credible or not. But they're going to have to prove why something is not credible. They're going to have to prove why something is not credible, because Congress still makes the law. Congress still makes the VAWA law. So USCIS can make their interpretation however they want. They can say whatever they're going to say right now about how they're going to judge VAWA cases and all that. But Congress still makes the law, and the law is still the law. And the most important thing that anyone can have on their side when they're filing for any of these immigration cases is just to have a dedicated lawyer that is not gonna just like roll over and play dead. You know, I'm not gonna bend my knee. I'm not gonna roll over and say, I give up. I'm gonna fight for you, my clients. So if you have been scared, because you submitted a case and you're worried about what this government is gonna do, well, first of all, F them, they will be gone in about 3 years, and they're going to do they're going to try to do as much damage as they can, but don't worry, we're not going to give up. We are not going to give in. We're going to persevere. So don't worry about that. Money Boy, hello, my lawyer. Peso mucho. I know that you're scared, and it's natural to be scared, but honestly, my love, this is what they want us to. They want us to be scared. They want us to give up. They want people to leave the country willingly. But you have made this your home. You have gone through a lot. You have gone through so much, guys. I'm speaking to everybody out there. Every single person watching this, especially if you're an immigrant or the child of an immigrant or whatever you have gone through a lot. You have gone through a lot, and you deserve to call this place your home. You deserve to make this place your permanent home. You deserve to be here, you know, and I don't care what they say. I don't care that they say that we're going to vet people extremely, or people, you know, they're targeting people, they're making people afraid. You deserve to be here. And while the law is still the law, we are following it, and we're filing cases according to the way that Congress has written these cases. And I'm going to fight as long as I breathe. Okay. Okay, let's see. I heard in the news that law firms in New York are getting many RFEs, especially those that do VAWA, U, and T visas. Is this the case in your office for Larsel? Larsel, we've been getting lots of RFEs since the beginning of this year, but I don't think it's any more than what other law firms are going through. Maxine, Merry belated Christmas. Hoping your family had a good one and staying safe and warm. All the best for 2026. Thank you so much, Maxine, and I wish the same for you. I wish the same for all of you who are watching right now. I hope you all had a Merry Christmas. Okay. Do you think work permits will still be processed? I did my biometrics in November from iSondi. Yes, absolutely. Work permits are still being processed. Everything is still being processed, guys. The only thing that's kind of on pause are asylum applications, but everything else is still being processed. Rufai, it was so nice to meet you as well, Rufai. Thank you. Let's see. If a conditional green card through marriage gets expired in June, till which month can you travel from Shreya Baral? Shreya, technically you can travel up until the day that your card expires, but again, I'm cautioning everyone, especially if you have a conditional green card, you're no longer living with your spouse, you're divorced, or one of you has moved on from the relationship. I definitely don't recommend that you travel because you are going to be at high risk of being accused of fraud if they ever go through your stuff and they want to accuse you of things. So Larcel, yeah, there's I don't know if it's law firm specifically in New York. I mean, we've gotten RFEs, but I feel like it's still like, I don't know. I think we've gotten RFEs on less than 10% of our cases, I would say, maybe, or 15% of our cases. La Rosita, I applied for VAWA with you and we had to submit request of service. They have given me 2 different receipt numbers. One is EAC and LIN, and I also received a prima facie for both, filed January 3rd, 2023. Is this normal? La Rosita, that's a very interesting thing. No, I don't think that's normal. Can you please call our office tomorrow morning and just let us know what because I can't tell which client you are. And I don't think that we saw that. So yeah, give us a call tomorrow so we can look at this. Okay, La Rosita. Okay. I received a notice of intent to deny for lack of financial mingling and joint assets. How serious is this case? I'm planning to respond with evidence. How's your experience with marriage-based NOIDs? We haven't gotten a lot of NOIDs in our cases. I think I've dealt with 1 or 2, and the couple that we got, I think we were still able to overcome. Now, if you filed an I-130 and an I-485 and you got an NOID for a lack of financial mingling and joint assets, I would say that's pretty serious because it means that they're basically doubting the validity of your relationship. They're basically saying that they don't believe that your marriage is real because you don't have bank accounts, you don't have joint assets or joint bills. So you need to respond back. You need to respond back with, ideally they want to see evidence because you can give them an explanation of why you don't have those things, but really the thing that they want to see is they just want to see the bank accounts. But of course, if you get a denial, you may still be able to reopen it. But hopefully you have a good reason for showing why you don't have that. Coach Riando, Moumita, I'm your client. They recently moved my case. Is that something that's normal? Should I be worried about it from Cocho Riando? Cocho Riando, I would say no, because I would say that when your case gets moved from one USCIS office to another, usually they're doing that because they are trying to redistribute their workload and get cases processed faster. I'm not sure exactly why they do it, but in my experience, whenever they transfer a case from one place to another inside the USCIS, it's because they're trying to redistribute the workload, okay? So nothing to be worried about, all right? Can you please tell me if 27 weeks is normal for receipt notice? I'm your client. It's been 27 weeks. Yes, my love, this is very normal right now. If you are filing for like a VAWA or a T visa or a U visa, the humanitarian cases, it's taking like 5 to 6 months to get receipts. So 27 weeks is about 4 months. It's actually pretty normal, and you probably still have a little bit ways to go. And also, I just want to let everybody know that everything slows down at USCIS over the holidays. Christmas, people are out on break just like you and me, right? So they have less people. They take more time to process cases. So especially if your case is, it's the Christmas holidays, the New Year holiday, and you still haven't received your receipts, you should probably expect that it might take even a little bit longer. Okay, but I know that we got mail twice today in the office. We got like big stacks of receipts 2 times today already. So they are giving receipts. If you are still waiting on your receipt from USCIS, it doesn't mean that you're never going to get it. It just means that they're having big delays. Okay. Yeah, and I have another question about receipts. I applied my VAWA in September, but I still haven't received receipts. Again, it's taking like 5 to 6 months to get receipts right now. Can my wife come to the US if she tried crossing illegally? I'm a US citizen from Olivo. I wouldn't recommend it if she's out of the US. It's just better to bring them in through the process through the consulate. Okay, it takes about 1 to 2 years. All right, guys, I have to get going. Last question, I-601A is proof. Can you do the interview here, or do you have to go out for an interview any other way? From T Custom Pergolas. T Custom Pergolas, if you have an I-601A approved, the only interview you can have is outside the US, unless you do some other process like I talked about earlier during the session, which is through either military parole in place, 245I, Section 245I, or a VAWA or a T, okay? Or a U, actually. So that's really the only way to avoid leaving the US if you want to adjust your status, okay? My telephone number is 212-248-7907. Our lines are closed right now because it's a little bit late, but call us tomorrow, save our number, okay? And my name is Moumita Rahman. Thank you so much for joining. Really, really appreciate all of you being here today. And again, for those of you who are scared about what is happening with this government, just want to tell you, don't give up. Don't give up, because most of these things are more, I'm not going to deny that there are some people suffering consequences and some people that are getting put in harm's way, but the majority of people are still okay. The majority of applications are still being processed just fine without any incident. So I don't want you to give up, okay? All right. My name is Moumita Rahman, and I'll see you next time. Good night and God bless.